Hello, everyone. We're Lawyer B, Group B5. We're going to talk about the issues that have occurred between Company A and our company, B Corp, and group of indigenous people. First, we will go over the details of the MOU signed between Company A and our company.
So let's move on to the first topic, trade. B Corporation, which Lawyer B, including me, represents, and Company A, which Lawyer A represents, had intention to form a partnership for international trade of natural resources, considering their respective outstanding business and achievement in pharmaceutical industry. Company A is a pharmaceutical producer and supplier headquartered in country A, while B Corporation is a bioactive ingredient supplier headquartered in country B. Regarding this attempt to build and develop partnership between two countries, two main issues affecting loss of transaction stability were expected. The first issue is that the parties need to classify and much understanding about this partnership each other in the relation of status of their countries. The second one is that we need to avoid and resolve future dispute on international trade between Company A and B Corporation. So, after a lengthy period of email exchange, we as Lawyer B and Lawyer A made MOU about this partnership. MOU, standing for Memorandum of Understanding, is so-called an agreement to agree before making a treaty or contract which has legal binding and stronger legal weight than MOU. The parties are respectively headquartered in WTO member countries. In that sense, they share a mutual interest in upholding the principle of sustainable development such membership represents. Moreover, the joint venture governed mutually is under the auspices of the bilateral investment treaty between country A and country B. Therefore, the MOU should have considered these legal points. In the MOU, the parties agreed on establishing and governing the joint venture within country B with foreign direct investment from Company A on the purpose of sustainable development of developing country B and stability of international trade based on BIT. In the joint venture, B Corporation exports natural resources to make a medicine named Bologna Slim to Company A, and Company A exports Bologna Slim to B Corporation. The MOU has been effective for 2 years since October 10, 2021. To take measures against the future dispute occurred, the parties agreed to submit any dispute relating this MOU to the International Center for Settlement of Investment Dispute for settlement by arbitration if the dispute remains unresolved for 3 weeks after communication about disputed matter to the other party. For more, we made sure that the parties have the right to hold cost share payment for any failure of compliance of the MOU. We also understand that having paper-based communication before any changes or attempt of new action by parties, which is not mentioned in MOU, is important. And in conclusion, we expected occurrence of dispute caused by vague wording in MOU, difference of interpretation of MOU, or other emerging issues in principle of MOU, process of MOU. So we included countermeasures to avoid and resolve dispute in the MOU and much understanding of the partnership considering sustainable development as WTO member and transactional stability of international trade based on BIT. That's it. Thank you very much.
Thank you, Saori. Secondly, during making a contract, intellectual property can be a problem. Intellectual property rights can be patents, copyrights, trademarks, and so on. They are all granted in order to balance between different rights, which are innovation and societal benefits. As Sari mentioned, we considered a case of the contract made between Company A, written as Comp A on the slide, and B Corporation, written as B Corp. And both Company A and B Corporation belong to each country signing to WTO. In the case, Comp A spoke to another company mentioned as AC, which produced resources for Bologna Slim, same as B Corporation, to sign a new contract. Since B Corporation thought that Company A only made a contract with B Corporation, Company A's conduct was unpredictable for B Corporation. Accordingly, B Corporation wanted to talk to A company to request to stop discussing with another company. As lawyers of B Corporation, we decided to write a demand letter to Company A. It is an easy way to ask or persuade someone to do or not to do something. Demand letters should include number one, client's position, number two, what the writer expects the other party to do, and number three, reasons the party should accept the request. Thus, this is an effective way for B Corporation to change an unfavorable situation. There are some applicable laws or rules to solve problems related to intellectual property rights under WTO. For example, 2001 Doha Declaration has signed to make developed countries promote an access to medicines and deal with infectious diseases in developing countries. This is known as compulsory licensing. Furthermore, Article 31 of TRIPS, which is called an Agreement on Trade-Related Aspects of Intellectual Property Rights, states compulsory licensing may only become possible for providing products domestically, and these treaties are applicable to this case because all of the companies in this case are in countries joining WTO. Consequently, we wrote Company A a demand letter based on Article 31B of TRIPS. The government or third parties authorized by the government can grant license without permission from the right holder, which is Company A, in a national emergency or other circumstances of the top priority. We considered Company A and another company started discussing without any national emergencies required by the treaty. Thus, as a result, we have decided that Company A was in violation of set rules and MOU made by Company A and B Corporation. And as a request by B Corporation, we requested Company A to end the discussion of purchasing resources with another company. That's it. Thank you very much.
Thank you so much, Haruna, for the great presentation. And next, I will talk about human rights, and especially the rights of indigenous people. So first of all, I will briefly explain about the issue here. So as Saori and Haruna have already explained, Company A and B Corporation has established a joint venture to collect the resources in country B, which will be used to produce a medicine called Bologna Slim. However, the resources are located in an area of country B, which is traditionally occupied by an indigenous group called IG. So therefore, the government of country B have to make an agreement with IG regarding the harvesting of the resources. So in conclusion, the issue in this case is to what extent does the country B have to provide protections to IG's rights? And since it is pretty complicated, I made a visual representation of the relationship in this case. So first of all, as I said, country A and B Corporation has created a joint venture to harvest the resources which are located in country B. And on the other hand, indigenous group IG, who are represented by lawyer A, own the resources in country B. And the government of country B, who is represented by the lawyer B here, have to make an agreement with IG. So secondly, I will talk about the applicable rules to this case. So according to United Nations Declaration on the Rights of Indigenous People, Article 27, state must establish and implement processes recognizing and adjudicating indigenous people's rights in relation to their lands, territories, and resources. So this declaration is applicable to this case because it is the most comprehensive instrument detailing the rights of indigenous people in international law and policy. So if we break this UN Declaration Article 27 down to each element, it's gonna be like the first element, it's gonna be indigenous people have rights over their lands, territories, and resources. And second one is gonna be state must establish and implement processes, and those processes should recognize and adjudicate indigenous people's rights. So thirdly, I will take this rule and apply to the current case. So the first element was indigenous people have rights over their land, territories, and resources. And in this case, we are talking about the resources to produce Bologna Slim. Therefore, IGs have rights over the resources. And the second element was that state must establish and implement processes. And in this case, country B has already entered an agreement regarding the harvesting of the resources. And the last element was that those processes should recognize and adjudicate indigenous people's rights. And in this case, we can say that agreements include the clauses which recognize and adjudicate IG's rights. So therefore, as a conclusion, given a situation in which country B has established and implemented processes to recognize and adjudicate IG's rights over the resources, it is fair to say that country B has provided enough legal protections to IG. And therefore, the court should find that as long as the joint venture harvests in accordance with this agreement, IG's rights will not be violated. So that's it from me. Thank you for listening.
Thank you very much. Now we have still one more problem. It's the corporate social responsibility. Now the joint venture consisted A, B corporation, which is us, and indigenous group would like to further protect its reputation by having the indigenous groups sign a non-disclosure agreement. We would like to make sure that consumers are not aware of their treatment of the group or the demands in the treaty. This is related CSR, which stands for Corporate Social Responsibility. It is, according to the World Business Council, corporate social responsibility is a continuing commitment by businesses to behave ethically and contribute to economic development while improving the quality of the life of the workforce, local communities, and the society at large. The business should emphasize not only economical market or profit, but ethics, sincerity, resources, responsibility, sustainability, and so on. And those goals need to be specific and for long-term setting. Recently, SDGs is one of the concrete guidelines. This is voluntary responsibility. However, SCR helps the business to gain the social credits from many people. Non-disclosure agreement is contract by which one or more parties agree not to disclose confidential information. The subject often includes trade secret, personal information, design process, and NDA would be signed when parties want to protect those confidential information. There is no legal restriction, so there is no penalties and fines if one of the party breaks the NDA. But the information would be known for many people, and this will cause problems about intellectual properties or privacies and serious problem. Generally, NDA is consisted of purpose of the contract, basic information, contents information which would be protected by NDA, such as ownerships, related laws or treaties, scopes, obligations, limitation, indemnity, like this picture. In this case, by the co-working, company A and B Corp can gain out of strong labor force and resources from indigenous people. In opposite, indigenous people will be able to be outgoing and earn more. In addition, they can learn skills each other and both can develop by interaction. However, those skills and technology is an important position for all of us, so they need to protect from outflow. They will be able to deal with problems related to intellectual properties or some skills by agreement of NDA. That's all from me. Thank you.
Thank you, Kosuke. And now we'll move on and talk about a possible future disputes. A possible future dispute is that the indigenous group violate the term sheet arrangements and demand that the collection of ingredients for Bologna sling be stopped or banned based on land ownership. We agreed our obligations on NDA or in treaty, but indigenous group might violate the treaty. For example, they might cancel the mining permission, impose new obligations that we haven't agreed on, or require much more reparation, and so on and so forth. Prohibition of the collection makes this business impossible to establish, and as a stakeholder, company A will need to cooperate to resolve this. If we ignore the indigenous group's requirement, we may be in trouble like litigation? If so, producing of Bologna Slim would stop. Maybe we can forcibly continue the business with support of government of country B, but by this option, the relationship between our company and indigenous people will be bad.
Now I talk about how to avoid the dispute. That this dispute will be able to be solved and avoided based on soft rule that detains only the parties. Since the term sheet has already been signed, indigenous groups will be less reluctant to sign an agreement with B Corporation. However, there is a concern that as long as the term sheet is regarded as a soft rule, that only establishes a factual agreement between Corporation B and IC. Therefore, even if the party violates this, the other party cannot immediately impose legal penalties for violating the term sheet. It is essential to build good relationship with the indigenous group. Hardline measures such as money harvesting from indigenous group might be a result of dissatisfaction with this business. For example, they want to do more the traditional method of harvesting, which is more sustainable and environmentally friendly way through the collection of broken flame ingredients. The discontent of the brokenness of business with the wages of indigenous people. In the same way, funding for the cultural promotion and joint programs as part of the country's CSR will also help building friendly relationships. Cultural promotion will deepen the understanding of indigenous groups to contribute people and help the realization of a society where the pride of the indigenous group is respected. And it will be effective to gain indigenous group favorable attitude toward big corporation. The most likely solution to avoid future dispute is to have a conversation on a regular basis. If the dispute occurs, the response is to send a demand letter to the indigenous group to where they will have a place to claim and discuss their branch of duty at first. The discussion demands Company A to attend the international group. In conclusion, we have worked on the MOU with Company A, demand letter, treaty term sheet, and DA. This business has a positive impact on our cooperation. There are certainly concerns about the leakage of confidential information, but it can be prevented if we take precautionary measures. Since we have signed NDA and MOU in advance, we can work on problem solving immediately. This business, which includes indigenous people, will be useful for expanding transactions in the future because it can appeal to our company's CSR externally. Therefore, it is worth maintaining our relationship with indigenous people and the Company A. That brings me to the end of our presentation. Thank you for listening.